See the one over there? On the bottom?
Oh, yeah.
That's what I used. That was a picture that was literally taken when we were out one day with the team.
Andy,
Yes.
Yeah, that's what I use for everything, cause it's like, what's that? It was literally a picture that was taken when we were out with the team, and I was with the whole group, and I just cropped myself, and I'm like, okay, this is my new phone.
Wow.
Ask Ashley, I changed my photo like 4 times last year and a half.
So my wife, she went and had a professional photographer for her very first one.
Yes.
She spent like $200.
Yes,
And.
All right, Rich, I just made you host.
I just told her I did the same thing.
And there you are for the whole, for everyone to see.
Here I am, we used, his name's Mason, Gina's son.
That's gonna be
That's
done
just-
tomorrow.
And that's where we got our photos from, and he's fantastic.
Your pictures are amazing.
Yeah, I'm amazing, so.
Oh, well, true, trophy
I mean,
husband that you
conceited
are.
much. It's only conceited, it's not conceited if it's not true.
Alright, that's fine.
But no, mine.
Notice he said nothing about how fabulous his wife is.
That happened to me with my senior pictures. We paid like 350 for them, and I only got, I think, like 5 photos, and they were blurry. I didn't
It's
send them
so
out, I
crushing.
sent them to
It's like, yeah, I had mine and it literally, it looks, you know, when you go to a law firm's website
Mhm.
and they each have their bio, that's exactly what it looked like.
Alright, guys, we're gonna get started. It's 11.
Are we it?
Well, yeah, but we have people on Zoom.
Oh.
So, thank you.
I'm on the Zoom.
I mean, you're welcome to come in. Let's see, I have a few people on Zoom. Hopefully you guys can hear me. If yes, I can't see any of your faces, so if somebody could just unmute for a second and say, yes, you can hear me, or no, you can't. Cause you won't.
We can hear you. I can hear you.
Oh, Mercedes, thank you.
I
Okay,
can hear you.
there we go. Alright, perfect. Okay, well, thanks for coming in today. Few updates about our buyer representation agreement. So we haven't updated the form, but I guess as we've gone through this, we're learning more about what actually the effects of it, and our clients are signing it. So I'll share some things with you. You'll notice at the top of ours, it says exclusive buyer representation agreement. So this exclusive agreement is no different than the exclusive right to sell agreement that we have. This is an exclusive right for you to work with that consumer and the consumer to work with you. Now, on a listing agreement, we have a little bit more control because you have a sign in the yard, you have a key to their house, and you know, realtors know not to call that consumer. But realtors need to learn that when you are in an exclusive agreement with somebody, you cannot talk to that client and try and get them out of the agreement they're in. Now, if they have a non-exclusive agreement that they've signed, sure, you can talk to them and see if they'll enter into an exclusive buyer representation agreement with us. But what I'm finding is I'm getting a lot of calls from agents that are saying, hey, a consumer doesn't want to work with their blank agent anymore from blank brokerage. What do I need to do? And the answer is you do nothing. You have no, that is an ethics violation. It's Article 16, and you would be found in violation if you say to that consumer, oh, well, don't worry, just because you have that sign, just sign mine and you can buy the house with me. And or you can also not, you should not be saying, well, call that broker and get out of it. I mean, what you need to do is if a client comes to you and says, I don't want to work with that agent anymore and I signed an exclusive agreement, what we need to say is you need to contact that broker directly. If you do not want to be in that relationship, you contact them directly. You don't say to them, oh, well, you need to get released from it. You need to reach out to that broker and ask for a release or anything like that. We should not be involved in those agents, whether they're getting released or not is not up to us. So consumers unfortunately have to learn that when they sign an agreement, if it's exclusive, that's exactly what it means. It's exclusive. So anyway, I just wanted to make everybody aware of that. Now, the exclusiveness of the representation agreement doesn't automatically mean that we're going to get paid also. So if you have an exclusive right to a representation agreement with somebody and they choose to go buy a house with somebody else, perhaps that could be a violation of Article 16. If that agent coerced them into signing something with them and kind of speaking negatively about us or you as the agent and saying, hey, come over to me and sign this anyway. The moment that other agent knows that there's an exclusive buyer agreement, they should end the conversation, and that should be the last time that they talk to that consumer until they would get it released. And I just kind of circle back and say all that just because we are seeing a lot of folks that are signing these and then they don't realize that they signed something. You should be giving a copy of what they signed. Anytime you meet with a consumer, whether it's in person, online, whatever, you need to give them a copy of what they signed. So if you're meeting with a consumer for the first time, let's say at 5 o'clock tonight, and you don't have two buyer agent agreements printed, so you can give them a copy of what they signed and you get the signed copy, then you should email it to them before they ever get there, or email it to them when you get to the house, they've signed it, take a picture of it, send it to them via text. You really need to make sure that you're giving the client anything that they've signed a copy of it. Whether that's a listing agreement, purchase agreement, or whatever. We've actually seen at the division where agents will go to a listing appointment, they will get a signature on everything, and then they never send the consumer the copies of what they signed. That's a violation, and we've been nabbed for that. So again, just some things, I don't wanna say updates as I did before, but really just some more knowledge that we have about these buyer agent agreements as we continue to go through them. So any questions about that? I know that certain people have ran into certain situations. I don't wanna get too far off topic, but anybody have any questions about that? Okay, all right. So we're gonna move forward. Like I said, we have an exclusive buyer representation agreement. That's our brokerage has chosen to do exclusive. You could have a non-exclusive agreement. Line 1 through 6 are pretty self-explanatory. It just says that this consumer is agreeing to work with us. Now, I have seen on line 6, agents will put in a time frame of, let's say, just that day. Right, they'll just say, oh, just that day. That way, if you don't want to work with me in the future, I need you to sign this, but it's only for today. That's what you want to do. That's up to you. I don't recommend doing that simply because what I have been seeing is, let's say Liz, I meet Liz and she does this. She has a 1-day agreement with me, and all of a sudden I go home, I talk to whoever, my parent, grandparent, whatever, and they say, well, you know, if you call the listing agent, you don't have to pay anything, possibly, right? And so then I'm gonna ghost Liz and I'm gonna go ahead and call the listing agent and go, yeah, I know I saw the house, but I wanna write an offer with you being unrepresented, or I wanna write an offer with you being represented. And now all of a sudden, we have a procuring cause issue perhaps, but your agreement expired at midnight that day. So they don't have an exclusive right anymore. That agent is no longer in violation of Article 16, but they could lose the money in the event that we take them to the board for procuring cause. So I've also heard agents say procuring cause is dead. It is not dead. It is absolutely still alive. Procuring cause is a series of events that would lead up to an offer that gets accepted. So if you don't abandon your client and you keep up with them, then we have a good way to get that commission dollars, even if you didn't close on it. So I'm gonna give you an example. Let's say that I meet with a buyer and I show them 15 houses or 10 houses, whatever it is, and they've signed this exclusive buyer agreement. All of a sudden, one of the houses that I've shown them, they've called the listing agent or another agent at a different brokerage, they start ghosting me, but I've done nothing wrong. I have not abandoned the consumer, I followed up with them and they're just ghosting me. The consumer is allowed to work with whoever they want, but that other agent hopefully would have asked the question, have you seen this house before, or are you currently working with an agent? That would be the questions that they should be asking. Let's say they don't ask or they do ask, it doesn't really matter. That realtor ends up writing an offer on that property and procures the buyer and it closes. We then could take that realtor and that brokerage to the board and win a procuring cause case, which means we would win all of the commission. Now, it's not a guarantee that we would win all the commission. That is up to the panel to decide, but it is a possibility. So I say that to you just because it is not dead, and just because a client goes rogue does not mean that we may not get paid. You don't want to do anything to jeopardize the sale with that other agent. You're gonna wait until it closes, and then we can file the claim. The only other thing you could do is, again, you don't want to interfere with that sale, but you could call the other agent and say, just so you're aware, I have an exclusive buyer agreement signed with that consumer, and also I showed them the house that you just wrote the offer on. Would you be willing to pay me a referral? So that's sometimes the first question. Some agents would say, oh my goodness, yes, I'll pay you a referral because I don't want to be taken to the board for procuring cause, because procuring cause is all or nothing. There is no splitting 50-50, there's no 75-25, it's all or nothing. So it is best to work out something with an agent, even if that happens to be you. Let's say you're the agent that stole a client unintentionally, but you now showed a house to a consumer that they've already seen. They never told you they had been in that house, or they said they came at an open house, whatever the case is. Oftentimes buyers lie, and so we just need to make sure that we're covering ourselves. And so in those instances, we might be the one that stole a client. And if that's the case, if you get a call from another agent that says, hey, those are my clients, I have an exclusive relationship with them, try and work something out. I know it stinks to give up money, but I'd rather give up 25% personally, myself as an agent, than I would losing all 100% of it after I did all the work. So that's what I would say about procuring costs.
Assuming that everything's in place, Rich,
Mhm.
and we have a procuring cause issue, do you as the broker pursue that?
Yes,
On our
so
behalf.
as the broker, I have to be the one to pursue it because I have to sign off on.
But do
any
we?
complaint. Would we?
Yeah.
Yeah, oh yeah,
Okay.
absolutely.
Awesome.
I'm happy to stand behind our agents to say, listen, if you have a consumer guide signed, you have a buyer representation agreement signed, and you have documentation that shows whether it's emails, text messages that you've been working with this consumer, or that you showed the house a showing time report, I'm happy to back you up. Now, what I will say is, if you come to me complaining, but you don't have the consumer guide signed, or you don't have the buyer agents agreement signed, representation agreement signed, I'm not doing anything because it's like the doctrine of clean hands when you go into court. You have clean hands when you go in, otherwise the court's not gonna hear your case.
Mhm.
So, an example of that, what I mean by that is I once had a tenant that did not have a driver's license. He was out driving and a trash truck from Canton City ran into him and he tried to sue the city. Well, he didn't have clean hands going into court because he didn't have a driver's license, so they weren't going to then side with that individual.
Sure.
So that's what I mean by clean hands. If we've done everything right and we're on the right side of the law, then we can support that. But if you don't have clean hands, we're not gonna go sign ourselves up to say, oh, give me a violation because I didn't follow the rules.
Right.
Yeah.
Thank you.
So, yeah, you're welcome. So I recommend on line 6, I would just say, I think that you should at least try and get a 30-day minimum agreement signed. You know, and you can do 5 days, 3 days, whatever you wanna do a day. You could say, I'm gonna do 5 days, and then if you like me, we'll sign a new one, whatever the case would be. You're welcome to do whatever it takes to get the consumer to work with you and start to trust you. But I would recommend a minimum of 30 days if you can get away with it.
In that case, if we do want to extend
Mhm.
that last page of the agreement, the addendum is
That's
plenty
right.
to do
Yep.
that, okay.
Absolutely, yep, that's why it's there, is to amend any terms that you might have in the agreement, absolutely, yep. All right, line 7 and 8, we intentionally put this in there, a lot of brokerages don't have it, but I mean, it's saying that. The buyer is saying, you represent that you are not presently bound by an exclusive written buyer representation agreement with another real estate brokerage. You need to point that out. You really need to say to them, have you signed something with another brokerage? Do you know what you signed with another brokerage? Was it an exclusive agreement? Was it non-exclusive? If they say to you, oh, I signed an exclusive agreement, okay, whoa. I can't work with you, as hard as that is to say. The words, I can't work with you until you get released from that, or if you don't want to work with that agent, you need to go deal with that. When you're ready, you come back to me. I can't help you with that. You need to call that brokerage and that agent. So, and again, sometimes that's gonna happen on the reverse, right? Sometimes it's gonna be done to you. So we all just need to make sure we're doing everything as ethically as possible, asking the question, are you currently working with another realtor or agent? And is it exclusive? Now, if they present to you a non-exclusive agreement that they signed, hey, you can work with that, great. But you need to explain to them, you're now signing an exclusive agreement, you're not going and shopping realtors now, you're with me. Okay. All right, and so we asked for their initials there. I have actually seen plenty of clients that just initial it, just like they do with anything, and they've already signed something with another brokerage. They just don't read it. So that's what I'm saying to you, we should really be pointing these things out. All right, and then it just goes over assistance. What is it that I'm going to do for you as your real estate representative? So there's some bullet points there, and then it gives the duties of the buyer. And you can see in that paragraph for duties of the buyer, it says that they're going to work with us. They're going to work with us exclusively. It's not that they can just go out and work with anybody. And so that's what, when you're sitting down with your consumer or talking to them, this agreement is really not meant to go meet somebody at their house or at the house you're showing. Run through this document within 30 seconds, get everybody to sign it, and then move about your day. It is designed for you to have a buyer consultation with the consumer to learn what are they looking for in their new home, understanding what it means to work with a realtor, what the fee is or commission that they'll be paying, and how we might ask a seller to help pay that and things like that. So it's really a consultation is what this is designed as. And then the property condition and due diligence, this can save us a lot of times because I have 2 lawsuits on my desk right now and a division complaint that consumers have sued our brokerage because they know that we have E&O insurance. And they basically said, oh, well, you knew there was water intrusion, Mr. or Mrs. Realtor. And that couldn't be further from the truth. We've never been in these homes as far as living in them. We go in, we believe what the seller tells us, they fill out a residential property disclosure form, we go about our day. Now, if you are aware of a defect in a house, you do have to disclose that. But most oftentimes, we have no idea as a buyer's agent, unless something comes up on a home inspection, we have no clue, right? We haven't lived in the house, we didn't hide anything or anything like that. This is somewhat of a protection to say when you're working with your consumer, listen, I'm not a home inspector. I don't claim to be. I have no knowledge or personal knowledge of this home whatsoever. So you cannot hold us liable in the event that something happens after the fact. That would be a seller disclosure problem, not a realtor disclosure problem. So you're buying it as is. And then professional service providers. So just as we may give you in home inspectors, we may give you lenders, recommend them. We may do all of those things. We are not vouching for these individuals. They are not a representation of Keller Williams. They are independent folks. And basically, you have the right to choose anybody you want. Just because we give you a list of people does not mean that you have to use them. And so that's what that says as far as we will give you at least a minimum of 3 home inspectors. Because the law is if you give a list of home inspectors, you must give a minimum of 3. But you do not have to give any. But if you only give 1 or 2, or if you give them a list and you have stars or check marks next to your favorites, or you have the word recommended anywhere on there, that is all a violation. So we have a form in .loop that provides a spot for 5 different inspectors. You can choose to put whoever you want on there. That is a personal recommendation because maybe you worked with them before or whatever. But it also has a big, large disclosure that says you don't have to work with these companies. You can choose anybody that is a licensed home inspector or a licensed inspector on the Division of Real Estate website for Ohio. So
What
just, no, go ahead,
I was
please.
just saying, would it be the same if you're recommending like lenders or something, you have to have at least 3?
So lenders, it doesn't say you have to have 3.
Okay.
I would recommend though that you absolutely have at least more than 1. I mean, if you're gonna recommend them, you should say, here are the top 3 lenders that I typically work with or that I recommend. You're allowed to say that, you know, or that I have a relationship with. But you wouldn't say for home inspectors, these are the ones I recommend. You never say the word recommend. These are the home inspectors that I've worked with. You can choose whoever it is that you want to, you know, hire. So, but a lender and title company, you can say, I recommend these, I've worked with them before, I can vouch for them. If you wanted to go that far, be careful vouching, because sometimes deals get hairy. But anyway, for a lender, I would always say the rule of thumb, give 3. You really should. And I think, at least in my arsenal of lenders, and I don't sell anywhere near what I used to, but I know that if I had an FHA buyer, who I'm sending them to. I know if I have a VA buyer, who I'm sending them to. If I have a conventional buyer, I know who I'm sending them to. And I also know if somebody needs more hand-holding, which lender I'm sending. Ones that like technology and do not like to be micromanaged, I'm not sending them to the lenders that love to give hugs and, you know, sit down with people and go over every single thing, because it drives them crazy. They don't like that, they don't want it. Like myself, I'm a cut and dry. Give me the facts, let's get on with our day. I do not need all the fluff. Some people like fluff, so you should learn who your lenders are that you can trust that will take care of the consumer based on their personality type. And then seller disclosure, it just says lines 50 through 56, basically, you know, the seller is disclosing on a residential property disclosure form anything that may be wrong with it, but we don't guarantee those disclosures because we've not lived in the property. Home warranty, and you know, there may be a home warranty. Now, we do have a relationship with America's Preferred Home Warranty here. And so therefore, that's who we would recommend that you use. You are not required to use them. If the buyer or seller says, no, I want to use whatever XYZ home company, okay, fine, that's your choice. You know, you're allowed to do that. And then when it comes to the compensation, that's really the biggest thing is lines 59, and then it goes through onto the second page to line 73. But let me start with line 60 through 62 is a required verbiage from the state of Ohio, from House Bill 466 that passed. It is now Ohio Revised Code. That sentence must be in our listing agreement, on this agreement, and anytime we are talking about compensation, it has to be there. So you'll see that very redundant on a lot of our forms, but it is required by law. And if any agent tries to tell you anything different than what those sentences say, they're wrong. This is allowed by law. And what I mean by that is one broker is allowed to pay the other broker. So if on our listing agreement or on their listing agreement, it is procured buyer agent compensation, and then you get to closing and it says the listing brokerage is paying us or our listing brokerage is paying them, that is absolutely allowed. You will hear EXP, Howard Hanna, they will all say they will not accept the compensation if it's written that way. So we, in order to try and work together with everybody, you won't see on any of our agreements that it says the listing brokerage is going to pay. There are only two options on the buyer broker compensation agreement: directly getting paid from the buyer or directly getting paid from the seller. We've done that to just streamline it so that you don't have arguments with other brokerages, because you are going to work with these other brokerages. It really doesn't matter, because our listing agreement says that the seller will pay directly to the buyer's broker. So that's why we were able to change those. Now, somebody else's listing agreement might say it will be paid through the brokerage. We do not operate that way. So on our forms, there's only two ways to get paid: directly from the buyer or directly from the seller. That's it. So you don't have to worry about having those conversations with other realtors, and they may not understand it. There are a lot of realtors out there that do not understand the difference between the listing broker paying you or the seller paying you. They don't understand. It is two totally different things. It's based on the wording in their listing agreement and the purchase agreement. Okay. And so here we've left these blank, line 63 through 69, and it's simply because we're not telling you how to do your business. We don't have a minimum commission. I would recommend, as on our listing agreement, it's a $3,500 minimum commission. We are flexible on that. We allow you to run your business the way that you want to run your business. But we would recommend that that is the minimum commission that you would collect, whether you're working with a buyer or a seller, but is not absolutely required. So line 63, 64, it just says that what the commission is that you and the buyer have agreed to. So the first blank on line 64 is a dollar figure, and that is typically because we're going to ask the consumer to pay a $2.95 additional commission fee. Now, you may, as an individual agent, have a $3.95. As a team, you might have $4.95. That's why it's blank, is because we are not telling you that you have to charge a maximum, but there is a minimum of $2.95. We have some agents that charge $6.95 and they're able to get it. So if you can do that, that's fine. The reason it's called additional commission is because commission is negotiable. It is not a brokerage fee. It's not an admin fee. It shouldn't be called any of those things. And then the second blank is for whatever the percentage is of compensation that you're getting. So let's just say that we're going to be asking for 3% and negotiated a 3% compensation with our buyer and $295 additional dollars in compensation. Now, you'll see the third blank right after it says, if left blank, it's not applicable. I always recommend leaving this blank unless you absolutely have to fill it out. The reason I say that is because let's say, for example, that I put in here, I'm going to have a minimum compensation of $3,500, because you heard me say that's what should be your minimum. But let's just say I put that in there. What I envision happening when a consumer gets in a tough spot trying to negotiate on their new house, they're going to come back to this document, at least I probably would if I were a savvy buyer, and say, hey, you know what? I'm sorry, Ashley, but you said to me that you would work for a minimum of $3,500. I know I'm buying a $4,000 or $400,000 house, but sorry, you said you do it for $3,500. I need that margin to come back because the seller won't accept my offer if I ask for $10,000 in commission. I need you to cut your commission. You said you do it to $3,500, so I'm going to hold you to that. That's going to be a real tough conversation with your buyer when you have given them the minimum of what you would work for, especially after you've shown them 15 houses on holiday weekends, evenings, and been on the phone with them. Usually the easiest person you think you're going to deal with is it turns out to be the most difficult transaction you've ever had most times. So I do not recommend filling that part out, just an FYI. All right, so then what we would do is on line 67, we've not seen anybody use this yet. We do not collect earnest money, or we do not hold earnest money in escrow here at our brokerage. But I will say that we would hold a retainer fee if you so chose to do that. So what that means is, like, when you work with an attorney, before you work with them, you give them a deposit. They work from that deposit and they charge you billable hours based on their time that they use, and then they take it away from that retainer fee so that they know they're getting paid. Once you window that down to, let's say, they collected a fee of $5,000 up front, and now you're at $3,400, they might say, hey, I need more retainer fee. That's how they guarantee their payment, right? So realtors, we haven't got around to that yet, but I imagine that at some point we could get around to that, and we've left it available for you. So let's say that you're working with a consumer, let's say it's an investor out of California or North Carolina or Florida or wherever it is. And they say, you know, I'm not in town, but I want you to go view 10 of these houses, do a video tour and send them to me. Okay, great. Well, let's hang on a second. You're in California. You haven't seen these properties in person. I'm not taking a human around. So I need to make sure that I'm going to get paid for my time, because you're saying maybe you're looking at homes in Cleveland, Columbus, and Cincinnati. I'm your agent in Canton, but I'm not your agent in all those other cities. So I need to understand that I'm gonna get paid for my time. So I might put something in here that, you know, I need $1,500 as a retainer. And if you buy something in the time frame that I've allotted up here on the first page that we've agreed to, so let's just say in the next 30 days or 31 days, let's just say that, if you don't buy something, you forfeited that $1,500. That is coming to our brokerage, and you would be paid out on your regular split. If you're on 80-20 or 70-30, or if you're capped, you'd get the $1,500. So that's what it was designed for and envisioned for. And I will say, we've had a couple agents try and say that I'll charge you by the door. I'll charge you by the showing. No, that is not our company policy. There's nowhere anywhere that we've allowed for that to happen. You cannot just change your policy differently from what our company policy is. We are a full service brokerage. We only get paid upon a closing, or if you negotiate a retainer fee up front with an expiration date. Those are the only two ways that we're getting paid. And you as a real estate agent cannot be compensated directly from a consumer ever. So if you go do a CMA, and let's say, because I've had people call me and they'll say, oh, Rich, well, we know you're a realtor. My grandmother passed away. Would you come do a CMA on our property? By the way, I'm willing to pay you $300 for your time, because we're not going to list it. It's just for the estate. My siblings are going to buy it, whatever. They cannot write me a check for $300. It has to go through the brokerage. And in those instances, we're happy to say we're not going to take any money out of that $300, but it must pass through the brokerage. Okay. All right. So any questions about compensation, or what you can and can't charge, or how you do it? Okay, good. All right, and then, and like I said, and I'm sorry, I should cover on line 70 and 71, we would credit any compensation you know, that a seller offers, of course, to this agreement. We're you know, if a seller says I'm paying 2.5% and we said it was 3%, well, the buyer's only on the hook for 0.5%.
I actually do have a question.
Yeah.
As far as like coming up with the percentage, I was talking to Gina about that yesterday, and I assumed that there was like an average or something, but I think you can't do that, right? Like.
So things that you can never say, and this is just for an education, we are all from the same brokerage. We are allowed to say that Keller Williams Legacy Group charges 3%, 3.5%, 8%, whatever we want to say. You can say that as a real estate agent licensed with this brokerage. So I'll give you an example. When a consumer says to you, well, what's the average commission that you would pay? That is a dangerous question that you never answer. You can say, I can't speak to what the average commission is in the area or what other companies charge. I can answer what Keller Williams charges, and we charge 3% or 2.5%. It's when I say the word we, it really means whatever you are negotiating, but as a brokerage, because the agreement's between the brokerage and the consumer, it's a we conversation, even though it's really up to you what your minimum commission is.
How do we determine that, like what we wanted, what's realistic, I guess?
Yeah, so what's realistic? So I would say, when the first company that I was with was Realty One, they're not around anymore, but at that time we charged 7% commission. 3.5% went to the listing company and 3.5% went to the buying company. As we've seen home sale prices increase over the years, I got licensed in 2002. We have dropped our commissions, and when I say we, I'm saying every brokerage I've ever been at. But I can say even Keller Williams, I think last year our average commission was like 2.75, it might have been 2.6 something on average for the entire brokerage. And that's because some agents were charging 3.5, some agents were charging 2.5, whatever. But I would say to you, if you can procure a 3% compensation, you're doing great, in my opinion. Agents have a sliding scale sometimes. Sometimes they'll say, well, Anything up to $200,000, it's 3%. Anything over $200,000, I'll do 2.5%. But you have to decide what your value is as the real estate professional and what your minimum compensation is going to be. I will tell you that I had a conversation with another realtor over the weekend. I could not believe it. I about fell off my chair when we had the conversation, but they charged a consumer 5% buyer agent compensation. 3% was paid by the seller and 2% was paid by the buyer.
Is that common?
Nope. That's why I about fell off my chair, because I was like, good for
And
you.
they got it.
They got it.
Wow.
I thought, good for you.
Yeah.
You know, but on a $400,000 house, so they were making a great paycheck.
Yeah.
Now, I hope that they would have, you know, I'm sure they showed their value and why the agent, you know, got that compensation, but I will also say I'm not gutsy enough to do that. The most that I personally charge is 3%. That's the most that I charge because I want to stay competitive. Also, again, home prices have gone up. I mean, you know, a $5,000 or $6,000 payday is pretty nice. But also I've put a lot of time invested in the client and things like that. So a lot of times people think, oh, you get all that money. Yeah, $5,000 payday or $6,000 payday sounds real good until you consider the split with the brokerage, the taxes that you owe on that, plus any local municipality taxes that you might owe on that, any advertising that you have out, the gas in your car, the insurance. You have a lot of business expenses that consumers don't realize that you have. You never really want to divide your paycheck by the number of hours you put in because you might be below minimum wage in some instances. So that's why I say don't discount yourself. But what I have seen is I've seen a lot of agents that'll say something like, oh, well, this will be an easy deal. The buyer and seller have already worked out everything. And so I'm just going to come in and charge 1%. You're welcome to do that, but I will tell you that is probably one of the toughest deals that may or may not close that you'll ever see. The ones that seem to be the easiest up front end up usually being the very hardest thing you'll ever deal with. So the other thing I guess I should say to this as I'm thinking is this agreement is for real estate. So if you get a consumer that's looking at mobile homes, those are not considered real estate unless they're affixed to the ground. And in order to be real estate, you have had to have given up the title to the vehicle and it becomes real estate and has a deed. So you can get this agreement signed by somebody, but we had an instance where a consumer went and bought another mobile home with somebody else. And then our agent wanted us to enforce this. Well, really, you didn't even need this technically because it wasn't considered real estate that they were looking at. You should still get it signed and there's nothing that we can do because they didn't buy real estate. So, all right. And then, you know, line 74 through 77, it just says, you know, that if an owner, if an owner breaches the purchase contract through no fault of yours, you wouldn't be obligated to pay, or you shall not be obligated to pay us. Typically, we are not going to enforce this contract. I will not be the first brokerage to sue a consumer for buying a house with somebody else. We may be able to take that realtor to the board for procuring cause and try and get the money that way. But the last thing we want in our brokerage or any brokerage and NAR and Ohio, we don't need the bad publicity that would be on the headline that says realtor or Keller Williams Legacy Group sues consumer because they didn't buy a house with them. That's all that the consumers would read and see. They don't care about the details that they engaged in a contract or entered into a contract. So we will probably never do that. If brokerages become in the future that way, then hey, we might jump on that bandwagon, but we will not be the first. All right, and then the protection period on line 78 through 81 just says that, you know, within 30 days, if that consumer buys a property within 30 days of the expiration date of this agreement, they still would owe us. I'm going to tell you again, we're not going to sue them. So the agreement is probably only as good as we're willing to enforce it. Sadly, we're not willing to enforce it to its fullest effect, but the consumer doesn't know that. So this gives you a little bit of added protection when you're going in to talk to the consumer. You can't just go buy it for sale by owner and forget about me. You're still going to owe us the compensation, right? And then termination, this is something that I really think is a great idea to put into our agreement. Not all agreements have this, but on line 82, I would say within a 5-day or 10-day advanced written notice. The reason I say that is because the reason that we put this in here was to protect you as the consumer so that this didn't happen. Let's say, for example, you did put in a week's time frame for your beginning date and end date on page 1, and you showed a property to a consumer, and they didn't like any of the ones that they had seen, but now all of a sudden they called a listing agent, and not on a property that you showed them, but just called the listing agent and went ahead over and entered into a purchase contract. Well, they didn't cancel this agreement with you, so technically they would still owe you the money. And what we don't want to happen is that exact same thing, which is where they would say, I looked at the house with you, now I went to go look at a house with somebody else. Oh, I want to terminate this agreement and I don't owe you anything. I wrote an offer with another agent. No, you had 5 days that you had to cancel this with me. So that means that from the day you give me notice, you still work with me for 5 extra days. That's when you can terminate the notice. So it is important that you put a number of days in here and stick to it so the consumer understands. I can't cancel that agreement in 24 hours. I can't cancel that agreement in, 72 hours or whatever it is. It's however many days you put in there. All right. And then confidentiality, there are a lot of times that we have confidential conversations that we have to keep quiet about. So example, you might have a consumer that's going through a divorce and they don't want people to know it, whether, the buyer or the seller or whatever. So make sure that you keep information confidential. You shouldn't be talking about it with other realtors in the office. None of us ever think that we're going to have that situation happen, and it does. My desk is very close to where Ashley sits, and I might be having a conversation with one of my buyer consumers talking on the phone or speakerphone or whatever. Ashley can hear me. And then all of a sudden 2 weeks go by and that buyer wants to see a listing that Ashley has. And now Ashley has all the information about my buyer, knows they're going through a divorce. They're desperate. They've got to find something. And now they're going to stick it to us. I have violated my client's trust. So you have to be very careful when you're in here talking on the phone or sending emails, leaving stuff on the printer. Confidential means it's your client, and that should be the conversations between the two of you. Agency, you still have to get the consumer guide to agency signed every time that you work with a consumer. In the beginning, you don't have it signed per house, but it is per client. I always tell agents, if you're working with a husband and wife, I usually only get one of their signatures. It is not a bad idea to get both of their signatures, because there's nothing that says that because you showed Mr. and Mrs. whoever a house, that Mrs. didn't sign anything and Mrs. is now the one that's going to go buy something and you're out. So getting identifying whoever your clients are and getting their signatures on this is really the smartest way to do it. Okay. And then that gives you your agency relationship, or specifies the agency relationship. And then consent to delegation, we did put this in there simply because people do go on vacation. Maybe, a house pops up that you're already out showing 5 other houses to a consumer and you need to delegate your authority as the buyer's representative to another agent. You are absolutely willing to do that as long as the buyer does not say, no, I'm not going to work with that other person, right? So you can appoint another licensed agent, but the buyer does have the right to veto that if they choose not to work with that person. Now, when you do that, just so you're aware, when you go to write an offer, or if that agent goes to write an offer that you delegated to, you both have to show up on the agency disclosure form, because you now have that agent has personal knowledge or is shown a property. And most likely when they're showing the property, a buyer is feeling like, hey, you're working for me, you're a representative of Keller Williams, so I'm telling you about my pre-approval, I'm telling you where my down payments come from, I'm telling you all these things about me. Where that comes into play is if you don't add them to the agency disclosure form, that agent could be, let's say it's my listing now, and I just worked with Ashley's buyers, and now I have all this private information about them. And now Ashley's gonna write on my listing. Well, guess what? I have a duty to that buyer as well. So then I might become a dual agent. So you just have to be careful with those agency situations and know who your client is, and the other realtor should not know anything about your consumer. Okay. And then.
I have a question.
Yes.
Is that something, so say I do go on vacation and I ask Liz to help me. If I look at my buyers and I say, Liz is going to be the one that will show you this, this, and this.
Yep.
We talk about nothing. We only talk about the house. And you just keep pushing forward. I already know all your financial information. She doesn't need to know. She's just showing you the home.
So she's showing the home, and so you're on vacation, but you're still gonna write the offer on a house that you haven't seen and negotiate for your buyer.
Makes sense.
That's the
That's
scary part, is you
got
can do that. We've all done it, right?
Right. Oh,
We've
yeah.
all done it, right? The bad part is you do not have the personal knowledge of that house because you haven't seen it. But do you really have your buyer's best interest?
No.
If you haven't seen that house and yet you're writing an offer and going, oh, well, do you want a home inspection? But Liz showed that house and knows that half the windows don't open or they slam shut. or the water was shut off to the toilet, or whatever the case was, are you really representing your buyer to the best of your ability? No. So adding Liz to that consumer guide or that agency disclosure is the best thing you can do. You can work out whatever you want compensation wise, that doesn't matter. You might say, Liz, I'm gonna pay you 10%, I'm gonna pay you 25%, whatever it is, and it goes through the brokerage for payment. You can do any of that stuff, but
Got
you
it.
have to make sure that you are representing your client, and if you haven't seen the house, it's a little difficult to do. I'm not saying it's illegal, but it's a
Right.
little difficult to do.
Makes sense.
And then fair housing, this fair housing statement, line 98 through 107 is in every single one of our agreements. It's required by law. It is the same in everybody's agreement. It doesn't matter what the agreement is. You cannot discriminate, and neither can your consumer discriminate against any of the 7 protected classes from the federal level and 9 protected classes in the state of Ohio, because we also have familial status and we also have military. So the military one is important because even though we may not have military bases all over, when somebody is in the military, you can't discriminate because you can't say, oh, well, they're probably gonna get deployed in a year and not be able to make their house payment or their rent payment or whatever. So we protect our folks from the military as well. And actually, I think it's ancestry because familial status is in there. And then ancestry, yep, and military. So there's 9, there is 9 in this one for fair housing for Ohio. And then cybersecurity, really, we wanna make, what's that?
I said that wasn't my test.
No, because Ohio has 9, but it's 7 from the federal level.
Okay.
That's why. Yep. Ohio, we're just special people. Only 2 states left to have dower rights and
We're one of
other
them.
protected classes.
And my last 2 deals involved our rights.
Yeah,
It was-
and it's a struggle.
It's hard for people to understand.
It is hard for people to understand. And then, so cybersecurity, 108 through 113 just says basically, we strongly encourage you not to put things in an email, and we don't need your account numbers, we're never gonna ask you for wire instructions, your credit card information, none of that stuff. If it looks like it came from us, it didn't, because we're not asking for it. So you never wanna be involved in wire or account numbers of any kind, earnest money, unless you're collecting a check and turning it in the title company. They can go right online and pay the earnest money directly to most title companies, or they can drop it off themselves. Okay. And especially with the wire, with their net proceeds, you never wanna be, oh, let me get the wire instructions for you, never. That you'll allow the title companies to do that. All right, and then any other potential buyers, this is just letting your consumer know that, hey, I am not only exclusively working with you, I have other clients that I'm working with. I might show Liz a home and I might show Ashley a home, and I'm sorry, what was your name?
Indy.
Indy, thank you. So I might show Indy a home. I'm working with all 3 of you that are in this room, and yet you all 3 are looking in a certain area with a certain price range. They're all the same. And so I just need to make sure that you are understanding that if Liz wants to write on the house, but Indy also wants to write on the house, I have a fiduciary duty to both of you. I need to make sure that you're comfortable with that, because you might both want to write on the same house. And in that instance, let's say that Indy writes it first, right? So I write with her and she's comfortable with me writing that offer. Well, now when I'm ready to write the second offer, that's a contemporaneous offer. That means that I need to let Liz know and get her written permission that she understands I've already written an offer on a house and you're giving me permission to write a second offer for you as the client on this property. I do not have to disclose that to Indy because I already wrote that offer the first time, but my second or third person, I have to let them know. And we do have a contemporaneous offer form in .loop for you to use for that disclosure. Okay. All right, and then it just says, it's a binding agreement. You get everyone's signatures on it. You do sign it as well. If you don't sign it, by the way, it's not going to be valid. If there's a complaint, just so you're aware, if you don't sign it, you don't have it countersigned, there's no validity of a complaint because you failed to do your duty, which is sign the agreement to make it valid. Okay.
How often do you have agents that don't sign their own?
It happens all the time. It happens all the time that agents send it to a consumer, it gets signed, they forget to sign it, and then they come and say, oh, well, this so-and-so worked with another, well, you didn't sign it.
Now, would you recommend, because I know for myself, when I'm writing an offer, I'm already going to add for me to sign. As an agent, I just go ahead, I send it to them, when it gets sent to me as well, I just sign it.
Yeah, that's fine.
Okay.
You absolutely can.
Wait,
Yeah.
this might be a silly question, we can't sign it first?
You could sign it first if you wanted to sign it before you send it to the consumer,
Seems like you
absolutely.
can't forget, because you
Right.
have to send it, okay.
I was like, cause that's what I usually do, I just sign now and be done.
The thing is anytime there would be a change on the form, so if you send it to the consumer and they can sign only, you're fine. If that's how you put it in dot loop, that they can only sign, but if you have it to where they can fill and sign and they make any change, it will delete your signature.
Yeah.
Okay,
So you have to be careful of that too, so you just need to make sure that the end product has signatures on it by everybody. Okay, and then you would just fill in your information here, and then yes, to Liz's point, line or page 5 is really just a blank page unless you need to make any amendments to it. They only sign this page in the event that you are actually exercising the right, or they are, to amend the agreement, otherwise, their signature's up here. This page is only for any amendments that you would have to the agreement. Okay. And so, let's say, for example, you do agree to a 3% compensation in this document originally, but then all of a sudden a seller says, well, I'm willing to pay 2.5%, and your buyer says, well, would you be willing to only accept 2.5%? Sure. You should go back and amend this agreement that says I'm only getting 2.5%, because technically that consumer signed something saying 3%. So technically they still owe 0.5% to the brokerage if you don't amend it, and that we could call them out on that to say, you agreed in this agreement to pay us 3%, you're on the hook for 0.5%. We wouldn't do that again, but it is available to us to do that. So make your consumer comfortable, you would amend that agreement. Now, we have been told you cannot go up on the agreement on the amendment for commission. So if you only charge 2.5%, but the seller's willing to pay 3%, you don't have the right to then cancel this agreement and then enter into one with 3% or amend it up. You can amend it down, but not up. So just be careful with that.
don't you typically have a conversation with them, like, before you make all this though, what they're willing to pay or no?
You should be having it. That's what I'm saying. Like, you should have a conversation with your consumer, a buyer consultation, if you will, so that they understand what it is that they're agreeing to. Because oftentimes they have no clue. And like I said, we had an agent that was able to get 5%. I mean, that wasn't just smuggled in there. They had to have had a conversation with the consumer, because when they went to write the offer then on the buyer buyer broker compensation agreement, they were able to say the seller is paying 3%, you're paying 2% for a total of 5%. If they wouldn't have had that conversation in the beginning, that consumer might have gone, whoa, I'm not paying 5%. What are you talking about? Where did that come from? So you have to have these conversations.
But technically, according to what you just said, Rich, let's say a seller is paying 3.
Yeah,
We've got a buyer agreement that says they're paying 3.
yeah.
So we could, if we were jerks, enforce it up to 6%.
No,
No, 3 is the total.
3 is the
3
total.
is the total.
It's the
Okay, thank
total. You cannot get
Right.
more, you cannot get more compensation than what is on this agreement.
Got it.
Makes sense.
So by that agent saying 5% on this agreement, they were able to
They had it.
procure the total of 5%. That's right. Yeah. That agent told me that there's another agent that they've seen in the area charging 8% buyer agent
Is
compensation.
it like a top agent in the area or something?
In that particular area, yes.
Okay.
I have heard of somebody doing that as well.
But I'm just shocked because, like I said, even when it comes down to our additional commission of $2.95, I have a hard time charging a consumer $6.95 or $4.95 because yes, that's more money in my pocket, but I'm also already agreeing to a 3% compensation. So, when somebody says additional compensation or additional commission, it's almost like giving a tip, if you will,
Right.
before you've even had a service provided.
Right.
You
So
know.
what is that for? When you say $6.95, that's, what are they paying additional for?
Well, so back in the day, we used to call it an admin fee or a brokerage fee. There was a local brokerage that got sued over using that terminology because agents were charging different compensations in that. So let's say their fee was $250. Some agents might have charged $350, but they were still calling it an admin fee or a brokerage fee. Well, it wasn't really the brokerage that was charging. It was the agent that was charging it, even though it got paid to the brokerage. So because commission is 100% negotiable, we now call it an additional commission. That's what we call it. So when you say what that $6.95 for our brokerage, I can answer to say that we keep $195 if you are on the 70/30 plan and we give you anything in addition to that. So if you charge $6.95, we only keep $195, you get the balance of that. If you're on the 80/20 plan, most agents are only charging the $295, we keep all of the $295. It doesn't mean that if you're on the 80-20 plan that you can't charge more than $295. You could charge more than $295. We're gonna keep the first $295 and you can get the balance of it. Again, it's very hard for me as an agent to say to the consumer, I'm gonna charge you even more money. Because if that's the case, why don't I just negotiate a higher percent in compensation? Right? Why wouldn't I just say I'm gonna charge you 3.5%? Why would I add on that additional compensation? It just, to me, it's a mind thing for me. For many people, it's not. It's like when I go to a restaurant or a place and they want to charge me a 2 or 3% credit card fee. Drives me insane.
Yeah.
I would rather you raise the price
Yeah.
$1 on every menu item,
Mm-hmm.
you know, for at a restaurant, or 50 cents or whatever, so that it goes across the board to help you with your costs. But when you have to charge me that additional fee, it drives me crazy. So that's my reality of it.
Yeah.
Yours could be different.
So do most agents charge this additional?
Well, the $295 additional commission is required.
Oh,
You must
but
charge
it
that
goes to the
too.
brokerage, the.
If you're on the 80-20 plan, it goes to the brokerage. If you're on the 70-30 plan, the agent gets $100 of that
Okay.
$295 back. So if you're an agent that probably sells less than, you know, maybe 20 homes a year or something like that, it probably isn't advantageous to be on the 70-30 plan and get that extra $100. That's only $2,000. You're probably gonna make a lot more than $2,000 on the 80-20 plan, and you're still gonna cap. But if you're an agent that's selling 50, 60, 70, 80 houses a year, absolutely be on the 70-30 plan, because when you cap, that's still another $100 you're getting on every one of those. That's $5,000, $6,000, $7,000 more in your pocket than you would get if you were on the 80-20 plan charging the $295, because you don't get any of it. So it really just, you have to make a business decision whether it's for you to be on the 70-30 or the 80-20. That's all it comes down to. Yeah, we only have like 10 minutes, well, I guess we went to 12:30, I think, so we could, let me make sure, so we could continue to go forward if there's anything else. I think that we did the buyer agreement, and then I can go over the listing agreement if you guys want to, otherwise I can let you get back to your day.
I don't mind.
I would say you are the new one.
Yep.
That's
All right, so India, we're gonna go ahead and go over the listing agreement, because that's where we're at is, add this.
No, that's why when you asked me that, I asked you, I didn't want to.
I'm putting it to listen.
Okay.
Oh, good, well then,
Let's hold it.
yeah, so that's good. So we've got two agents here that are newer to listing, so let's go ahead and go over the listing agreement. Where did that go? There we go. All right, so I'll go ahead and pull that up. So our listing agreement is really, it's only 2 pages. It's not very aggressive compared to the 5 pages of our other document, but it is smaller print. We do have a small print, a regular print, and a large print. So if you have consumers that need more print or larger print to see it, that's available to you. But this is the listing agreement. So on the listing agreement, the exclusive right to sell agreement, otherwise known as, this would be the property address. So you'd put in there, you know, 1234 Main Street or whatever it is that your address is in wherever it is. And then whatever the listing price is gonna be. So let's say we're listing a house, it's $249,900. That's gonna be my list price. And then in order for a listing agreement to be legal, you have to have a beginning date and an end date in the state of Ohio. I see a lot of agents that go out on appointments, and a seller might say to them, well, I'm happy to do all the paperwork with you, but let's not put a listing date in there just yet, because I don't know when I'm gonna be ready to sell it. I might be ready in 2 weeks, I might be ready in a week, I'm not really sure. Well, I will just tell you, when you leave and this is not fully signed, that consumer, another agent can swoop in, get a listing agreement signed, or that consumer can sell it for sale by owner. They can do whatever they want when you don't have this signed. So, and you don't have the dates in there. So it's my recommendation that you would always meet with the consumer and get a beginning date and an end date when you're there at the property with them. Because if they sign this and you fill in that later, that is actually an illegal listing agreement. Agents do it all the time, but it is illegal.
So if they've said that to you, Rich, how do you approach that conversation? You know, I'm gonna put a beginning and end date. Is it, we can amend that?
You can-
Or that doesn't mean it has to go live in the MLS and be available to consumers as of that date?
Well, so that's the thing, that's where it gets tricky, is because if I put it, let's say I put a beginning date, they tell me, oh, wow, Rich, I'm probably not gonna be ready until the 23rd of June. And I say, well, I'm leaving, you know, your house today, I wanna make sure that we have this secure. So I'm gonna go ahead and put in today's date. and then, I'll put it in for a 4-month listing agreement or whatever. 3-month, so I put that in, right? Well, the problem is now I have a 6/12 start date for my listing agreement, which means it needs to be in the MLS within
Within
48 business
Okay,
hours.
yep,
And 24 hours of any public marketing,
yep.
right? But in our scenario, my seller said, I'm not ready to list yet, so I'm not putting a sign in the yard, I'm not putting it on Facebook, I'm not doing any of that stuff. So I have the 12th in here. What's gonna happen is I'm gonna need to amend this with the seller when they call me and say, oh, the 23rd, and then I can say, okay, great, we're gonna put the 23rd. That way I can put it in the MLS. If I'm audited, I'm okay. But I've also seen where agents will leave the house and they have it listed as of the 23rd, let's just say, and the seller signs everything. And the agent's so excited about their new listing, they just put it out there on the internet and say, I have a great new listing coming in Perry Township. It's priced at $249,900, 4 bedrooms, 3 bath, whatever the case is. Great, and you put a picture of it. Well, now there's a buyer or another agent out there that goes, I know that house, I know those people. When does your listing go live? Oh, it won't be live until the 23rd. Oh, I'm gonna go knock on that door as the agent and I'm gonna say, you know what, Mr. and Mrs. Seller, I can save you compensation because I'm only gonna represent the buyer. I'm not gonna represent you, or I'll represent you for a lesser amount and be a dual agent, whatever. Well, guess what? This listing agreement doesn't start until the 23rd. That seller
So
could,
technically he can go.
so technically they can. So
Yeah.
that's why you have to be really careful about, a lot of agents are saying, I had an agent call me earlier this week and they're like, well, I have a listing coming next week. Can I put it out there? I know I can't say coming soon and I know I can't advertise it, like the address publicly, because that's, then I have to put it in the MLS. Yeah, you can do that, but if somebody recognizes that property and goes and knocks on the door of that seller, there's nothing that says that you're owed a compensation until this agreement is in force, which is next week. So that's the scary part. That's why I say, I do not share my listings until I have a listing agreement signed and I'm within that 24-hour or 48-hour window of putting it in the MLS. Simply because I don't want somebody to go steal it out from underneath me, and it can be done. So anyway, so that would be, like I said, typically we see 6-month listing agreements. You can do 3-month listing agreements. I would stay away from a year listing agreement. That is really just way too long. You should not be going longer than 6 months unless perhaps it's $1 million plus home or an $800 and some thousand plus home that's in a $400,000 neighborhood that the market time is going to be longer. But look at the market times and you can adjust that. It's negotiable with the seller, but typically we do 6 months.
So at what point, I know you were talking about the dates have to be put in, and you can't. Or wait, so at what point do you give them, not the form I give them, the paper, but like, I don't know how to ask this question, I'm thinking. Never mind, I'm gonna think about it and I'll ask you after.
Okay, all right.
So much.
Alright. Now this part is where, again, you see that the wording is exactly the same in bold that it was on the other agreement as far as how compensation split or paid. But this gets a little confusing here on 1 and 2. So you can ask as many questions as you want, and I'm gonna try and explain it the best way that I can and why we did this document this way. All right. This is how I envision, and this is how I have had conversations with my sellers. Not all of these A, B, and C are applicable to your seller if they don't agree to them. It's only applicable if you agree with the consumer or the consumer agrees with you. So I'm gonna give you, for instance. All right, A is always going to be filled out for sure. That one we know for sure. 1A will always be filled out because that is where I'm going to put in. I already have my $295, but let's just say there is an agent charging $695, so I'm gonna put $400 in there because I have the $295, my $400, which makes it $695, and 3% of the full purchase price. Okay, so that's my listing commission. Now, I might also not have a listing percent commission. I might be charging a flat fee of $3,500, as it says here, not less than $3,500. And this is a 0% because I do not have a percent. I'm only charging a flat fee. Or I'm charging a flat fee of $10,000 perhaps, right? So it can be universal. It can be a percentage or an amount. And if I am the agent that I am, I'm going to put 0 in here and I'm going to put 3% because I already have the $295 up here. I'm not charging any additional commission, right? So that's already there. So that's how that was designed to be filled out, okay? Now, the next way the conversation is 1B. All right, Mr. and Mrs. Seller, I am going to represent you in the transaction. You're going to owe me the $295 plus the 3% to Keller Williams Legacy Group Realty. If a buyer shows up at an open house or calls me on the phone to see your property, but does not want any representation, they say, I don't want to pay an agent, I don't want any representation, but they still want me to show your house, I'm going to charge you then the $295 and a 4% commission. The reason I'm gonna charge you 4% is simply because the buyer claims they don't want any representation, but I still have to write the offer on your property, be here to negotiate for home inspections, sit here during home inspections or whatever. So I'm gonna charge you 4%. So I can get more compensation for my time for that. Now, one of two things is gonna happen. A seller's either gonna say, that makes perfect sense to me, I'm okay with that. Or the seller's gonna say, no, Rich, I don't know. I don't care what you have to do for an unrepresented buyer. If you want more compensation, you'll get it from the buyer. I'm only gonna pay you 3%. So then I would have 3% in there. So it depends on the conversation with the seller for 1B. Same thing is true for 1C. I can say, Mr. and Mrs. Seller, a buyer showed up, they called me, I showed them the property, they want me to represent them. I'm gonna be a dual agent. In a dual agent situation, I'm gonna charge you 5% because I'm doing all of the work for the transaction for both the buyer and the seller. The seller might say, oh, that makes sense to me, I'm willing to pay you 5% to be a dual agent. Or the seller might say, again, Rich, I don't care if you want compensation from the buyer, you get it from them, I'm only paying you 3%. So if my seller has been stern with that, you're gonna notice that in all three of these boxes, it's only 3%, which means I am only getting paid $295 plus 3%, no matter if I'm a dual agent, no matter if I have an unrepresented buyer, or if I just represent the seller. Doesn't matter, all three of those situations. Now, again, I might have a seller that says, Rich, I'm totally okay with you getting paid 4% for an unrepresented buyer, and if you're a dual agent, I'll pay you 5%. Great. So you don't know what you're gonna run into until you talk to the consumer. All right. All three of those scenarios have nothing to do with buyer agent compensation. That is just you as the listing agent in those three different scenarios, has nothing to do with buyer agent compensation. So let's say that my seller says to me, Rich, I'm happy to pay a buyer agent compensation, but I don't know what it's gonna be. I'm not gonna put a blanket compensation of 2.5% or 3% or whatever it is you're recommending out there. Let them bring me an offer, we'll negotiate it from there. Great. I'm gonna put 0% there, because the seller is saying, I'm not offering blanket compensation. I'm gonna have the seller's initial here saying that they are not offering any blanket compensation. Now, if the seller says to me, I'm willing to pay a 2.5% compensation, great. You initial here, I will then answer when a buyer's agent calls me and says, what compensation is your seller offering? They're offering 2.5%. But if the seller said, I'm not offering blanket compensation and it's a 0, my answer is going to be, my seller said it's negotiable, so I would ask that you bring an offer and we will negotiate it.
Mhm.
Okay, so the third way this conversation could go to add more confusion, if there isn't already some, would be that my seller might say, I'm willing to pay 2.5% compensation to a buyer's agent. Excuse me, in that case, I'm gonna go back and I'm gonna change that if I'm a dual agent, the seller is still only paying me 3%, because now I'm getting the seller's compensation because I'm representing the buyer. So that's why I say to you, all of these situations are not always applicable to your seller. You do need to fill them in, but it depends on the conversation you're having with the seller. They might be okay with paying you more in a dual agent situation. They may not. They might say, again, I'm not gonna pay you more in a dual agent situation, but I'm offering blanket compensation, which you will get if you represent the buyer.
So in this situation, let's say they say we're not willing to pay dual agent compensation.
Okay, so we're gonna leave it at 3,
Right,
okay?
but the 3 is not your cap, because you could do a buyer agency agreement with your buyer for 2, so you're getting a total of 5, but part is coming from the buyer. So this only applies to your compensation from the seller.
That's exactly right. It has nothing to do with the buyer.
Got it.
Nothing to do with the buyer. So let's just say, for example, Liz, following your logic or conversation, my seller has said, Rich, I'm only paying you 3% no matter what the situation is, but I'm willing to pay 2.5% buyer agent compensation. So Rich, if you bring a buyer, you're getting that 2.5% because I'm offering blanket compensation to any buyer's agent. That includes you. Okay, great. I work with my buyer says, I'm willing to pay a 3% buyer agent compensation, I get that signed on the agreement we first went over, great. I already know that my seller was offering 2.5%, so I can say to that buyer, yes, I'm negotiating at 3%, you are only paying me 0.5% because the seller has already agreed to pay 2.5%, and I know that because I'm the listing agent, right? So that's how that conversation would go. Now, you could also say to that buyer, I know that my seller is paying a 2.5% compensation. Everybody knows it because it's blanket compensation. I will work with you for 2.5%. You can do that because you have that inside knowledge. So, like I said, it gets a little confusing. I don't feel like it's that confusing, but I know that agents can get confused by it. Sellers can get confused by it, but hopefully those explanations let you know all of those situations, that is only the conversation of what your seller is paying you and or a buyer's agent
Yeah.
is nothing to do with the buyer. Okay, any questions about that? Okay, easy enough, good.
I'd say the Zoom chat is quite quiet today.
The Zoom chat is very quiet today. Well, they're probably all doing other things. They're just like, hey, I'm gonna show up and put myself on there, but I'm not really paying attention.
Caitlin and.
Mhm.
I'm not kidding.
Christine Powell, Amy, and then Tracy, so, yeah. All right, and so then going.
Oh, Deb said I am.
Oh, Deb's
Don't-
paying attention.
Let's not
Thanks,
forget
Deb.
about Deb.
Hi,
She's
Deb.
here. Hi, Deb.
We love Deb.
Mhm.
All right, so that would be the buyer's agent compensation, and then it just says all commissions, paid by the seller upon the sale, transfer or exchange, are immediately upon transfer of ownership interest, whatever. I will tell you, there are times that sellers just have a fit with these types of agreements. Some of them read them all, some of them don't read them all. Sometimes you have to cross things out. The only thing I would tell you is if you have a seller that wants us to cross things out of this agreement, you need to check with me first, because depending upon what it is, we may or may not be able to cross it out. So we had a seller once that said, the last couple sentences they want to cross out. So if any buyer or their representative contacts the seller directly about the property during the terms of this agreement or any extension of it, the seller shall promptly notify the broker in writing the name of the contact. The seller said, no, if I can sell this property myself, then I'll do it. No, this is an exclusive right to sell. We don't have a non-exclusive right to sell. We are a full service brokerage. If you want the opportunity to sell the property on your own, or we can sell it, that's an exclusive agency. That is not an exclusive right to sell. That's an exclusive agency agreement, meaning that you can sell your property yourself, or that agent can sell that property or that brokerage, but not any other. So we don't do that. Are you handling the chat? Oh, I see. Okay, thank you. All right. And then the state agency disclosure form, just so you're aware, whenever you present an offer to your seller, the first thing, now I understand we're on the listing agreement here, so that's why I'm saying to you, when you are the representative of the seller, when you get an offer from a buyer's agent, the first thing that you do is you give the seller the agency disclosure statement that says who represents who in the transaction. You're gonna request that seller to sign that agreement, even if they're declining the offer. It doesn't matter. Before you present them with the offer, I don't care if you have 50 offers. Yes, it's a pain in the butt, but you need 50 agency disclosures signed, because you have to have every agency disclosure signed for every offer that you have before you present the offer. Now, the seller might say to you, I decline signing that. Okay, fine, right in there, seller declined to sign, but you must present it to the seller and request their signature on it. And keep that on file that you did that. So that's before you present an offer. All right, then let's go over lockbox access. So basically, this is just saying that you have the right, which I will tell you, don't do this, but our agreement says that you have the right to give a third party the lockbox code to the property, whether they're a licensed inspector or not a licensed person. You never, ever, ever give out the lockbox combination without having it written down from the seller, their permission. So if you have a termite inspector that's going in, sure, the termite inspector might be a home inspector that's licensed with the Division of Real Estate in the state of Ohio. That does not mean that the seller authorized to give that code to that person and you just arbitrarily let them in. It doesn't make a difference if the house is vacant. You still need the seller's written permission to go into that property. So in showing time, you have the ability to set it up to where inspectors and appraisers can set up their own showing in there. So when you're doing your listing agreement, you ask the seller, are you comfortable allowing the appraiser to come into the property? They are licensed with the Division of Real Estate, they hold insurance. Would you be allowing them to come in using that lockbox even though I'm not present? They might say, yes, great. So when you set it up in showing time, even though it's pending, inspections and appraisal are still allowed to set up a showing on that property. And the seller then has the control to approve or disapprove that person coming in. That's the best way to do it, just in case. You didn't know that that was an option in showing time. You can do that. Also in showing time, you can uncheck the box that says that appraisals and inspections can be gone through during a pending transaction or can be requested. And in those instances, then they're gonna contact you. And then you have to work on getting them into the property. It's much easier allowing seller has the control, which is nice. So sometimes the seller might say, you can't put a lockbox on my property. I want you here for all showings. Great. Cross off that lockbox access because you're not doing it and have them initial next to it as well as you. Again, you never ever give a lockbox combination out to a buyer or anybody of that, even after the deal is closed. I'm gonna tell you why. So let's just say that Indy and I have a listing together. And I'm the buyer's agent, she's the listing agent. And I do not have the time to run over and get the key for my buyer. But India, I already know the lockbox combination because she told me what it was. Obviously, we've shown the property several times. So I say to my buyer, well, the lockbox code is 1234, just go ahead and get the key out of the lockbox, that's fine. Well, little did I know, she uses the same lockbox code on every single one of her lockboxes. So now that buyer or their buyer's family or whoever they send over now knows the lockbox code to every listing that she has out there. So when they look it up online, they go, oh, that agent was the agent that listed my house. I know that lockbox combination. Now they have access to every house she ever has listed. That is why you never give a lockbox combination out to anybody. All right, so again, a seller sometimes will ask for a lockbox code and they will then give it to a contractor of their choosing. That's up to them, but you better get it in writing that they're the one giving the code. Because if you're the one that gave the code to the contractor or whatever, and there's damage to the property, we're gonna be liable. Okay. So it's really never a good idea to even give the lockbox code to your sellers, because we've seen sellers just give that lockbox code out to everybody, their house cleaner, whoever it is that's coming in, contractors working on the property, painters, things like that. So again, the seller could put their own lockbox on it if they wanted to and give out that code, but we really shouldn't be helping that. I know you will, but just be careful. Right. And then authorization to market, this is saying that we have the right, or the seller is giving us the right to put floor plans out there, photos, drone photos, you name it, whatever, it's gonna be out there, it's gonna be published to everybody and their brother, it's probably gonna go out to every website known to man, and the seller is okay with that. Sometimes the seller is not okay with that, so you need to make sure that they are okay with that when you're going over this agreement. Sometimes we have judges or sheriff's offices that say, I don't want a floor plan of my house out there. No, because then if somebody breaks into my house, they know where everything is.
Right.
And so they'll say, I don't want that. Now, most sellers don't think like that, but they could. So just because they're not a judge or a police officer, you need to make sure that the seller understands this is going out there, and once it's out there, it's out there. I can't take it down because I'm not in charge of all the thousands of websites that it goes on. So as long as they're okay with that, then that's fine. But we are gonna market the property, putting a sign in the yard. Sometimes the seller might say, I don't want a sign in the yard. Okay, fine, I won't put a sign in the yard.
So at what point are you asking them about that? Cause that's something that I'm interested in. I like making videos and stuff. And I was wondering that already, like at what point are you allowed to start recording if you're like, if I'm shadowing somebody in a listing appointment or something? Cause I shadowed Gina the other day, but I obviously didn't record because I wasn't sure. So when,
You need
Yeah,
the seller's
when you know.
permission to
Yeah.
record inside their property.
but
Yep,
at what
absolutely.
point do you like bring that up in your?
Well, if you're on a listing appointment and Gina was getting the listing agreement signed and the seller, Gina went over this agreement with the seller and the seller signed it, then you're gonna have the right to do a video in their property. You'd still stand there and say, do you mind if I take a video, you know, before you do it? But that, once this is signed and they've agreed to it, then you're okay to do it. What you can't do, and I'll just say this because you asked the question, is let's say you're a buyer's agent and you go into a listing of Cutler's or Howard Hanna's or Keller Williams or anybody's, and you start taking a video.
Mhm.
Or you start taking pictures and posting them out there. That's 100% no-no.
Yeah.
You have no right to take photos or videos inside of somebody else's residence without their written permission. So if you're gonna do that, and I'll give you the example, I've got a buyer in Florida that says, Rich, I wanna buy a property up there in the Canton area. And I'm not there, I want you to go do a video tour with me on FaceTime. There is an option in showing time to do a video tour. That's the one I'm selecting and getting approved. Because if I just select showing and then I still do a video in it and I send that video, I have now violated the seller's trust and or the seller may not have allowed me to do that.
Right.
So you have to be very careful.
If you do something like, I use Google Meet
Sure,
because I'm not an iPhone user,
okay,
but it's live.
Yep.
And it's not, I never have it retained. It's not a video, it's basically just a projection
yep,
of what I'm
but it's still
seeing.
a video tour.
Okay,
It may not be recorded,
yeah,
but it is a video tour of somebody's home.
Okay.
So if you are going to take photos or a video inside of a property, you need to let the listing agent know and get permission, because they should be getting permission
Yeah, I
from their
always do.
seller.
Yeah.
But yes, yeah, and like I said, the nice thing is showing time has a drop down for that. It's showing, second showing, video tour, so you can get that approved right through there without having to worry about it, which is nice.
Yeah.
But yeah, you always wanna make sure you have the permission from the listing agent, really the seller, but through the listing agent, that you can video or record inside somebody's home.
And that goes in the listing agreement, whenever they're signing that, or is that?
It is in our listing agreement, and it does say that we can take interior photos, drone photos of the property, have and we will have digital marketing for that property. It does say that. And again, you as the listing agent are getting that approval in this agreement. But as a buyer's agent going into somebody's home, I don't know that Howard Hanna or Cutler's listing agreement gives permission for that, right? So you need permission from that agent who will get the permission from the seller if you're doing a video tour in their home. Does that make sense? Okay. All right, and then electronic surveillance, you might as well just figure there's electronic surveillance in everybody's home except for the bathroom these days. You are not guaranteed privacy anywhere except for a bathroom. That's probably the only place that you're guaranteed. Hopefully your bedroom, but also the bathroom. When you are touring a home, I mean, you can see cameras almost everywhere, whether it's from the Ring doorbell, when you pull up, whether it's a Ring camera that has, you know, on the garage or whatever the case is, over the back deck, whether it is in the baby's room, they have a monitor there, watching that, whether it's a pet camera, it doesn't matter. You might as well figure that if you're in somebody's home or outside of it, there is some type of surveillance, but ask the seller. Right, so I can say, if you were coming to my house, I refuse to have cameras inside my house. There are only 2 of us that live there and a pet, I do not want them, I know that that may seem old and absent-minded to think that somebody could log into that camera and see it all. But I don't know that they can't do that, I don't know that there can't be somebody watching me on this camera right now that is not on this Zoom, right? I have no idea, so I don't trust that that's there. So the only place I have cameras is on the exterior of my home, and that's my choice, right? My phone is already listening to everything I say, whether it's in my house or not. I don't need more things in there. So I would still check seller does, because I have Ring cameras on the outside of my house.
Yeah.
So if you're talking on my front porch or around my property, I can probably hear what you're saying. Now, the other reason that we have this in here is because in the state of Ohio, Ohio Revised Code says you do not have the right to audioly record somebody unless you're a party to the conversation. So if I'm in this room right now, I can record this entire conversation and never disclose to you guys that it was recorded. And I can have a phone conversation, not disclose that. If I put my phone down on record right now and I walk out of this room and I record your conversation, 100% illegal. I cannot do that, right? So that's where it comes into play. I can tell you, we've had sellers that do have these cameras. An agent and or a consumer of the agent has said something derogatory about the seller, their house, their family, their pet, their whatever. The seller goes back and watches that footage, and now they want to turn somebody in. Well, they could if they wanted to, however, they had no right to record that conversation. So they might be on the wrong side of the law. So that's why we ask the question, do you have electronic surveillance, yes or no? And if there is, you should put in the broker remarks, electronic surveillance on the property. You should disclose that so people are aware of it.
Is that what the remarks, that's what you're writing as you're like touring the home, right? Or are you talking about something else?
As you're touring the home as a buyer's agent, Is
So
that,
as a listing. agent,
oh, as a listing agent,
Or is that not what you?
I'm gonna ask the seller, do you have electronic surveillance?
Okay.
Yeah, I'm gonna ask them, do you have electronic surveillance, yes or no? And then when I list the property, I'm gonna put in the broker remarks in the MLS, electronic surveillance on the property. Right, cause I'm gonna disclose that, but I'm kind of covering both listing and buyer, cause I'm trying to make you aware that. Surveillance is everywhere, be careful what you say, there was an agent at a different company, she flicked off a Ring doorbell camera, the seller found it. And she got her license suspended for 30 days.
I heard about that.
What?
They
Yeah.
definitely not
Not hear about that.
I think that she was having some problems with this particular,
It was her
it
listing.
was her listing.
Yeah,
I think she
it
was
was her
having some
client.
problems with
And she
her
flipped off.
seller and she flipped them off and they turned her in, so.
So
and
real
then-
estate jail for 30 days.
And then the fair housing violation, again, it just says, don't violate fair housing in the protected classes. Disclosure, it just says that, the seller, you're gonna talk to the seller, disclose everything and anything you know about this property. I don't care if it's 10 years old, if you had a leak in the attic 10 years ago, disclose it. And just say that we had it replaced, the roof replaced, whatever it was. People are gonna find stains, they're gonna find different things that you think that you've fixed or done whatever, they're gonna wanna know what happened. The disclosure, you are not allowed to help the seller fill out a residential property disclosure form. The best thing to do when you're in a listing agreement is to say to them, I'm gonna go take photos, or I'm gonna go with the photographer, I'm gonna go do this, I'm gonna do whatever. Here is the disclosure, fill it out to the best of your ability. I cannot help you answer these questions. Cause a lot of times when you're sitting there with them, they'll say, well, during a heavy rain, I get water in the basement. What should I say?
That.
Then you should say whatever you just.
True.
Yeah, it's what
Whatever
you
it is
say.
that you think you should say, that's what you should, I cannot help you fill out that document. Also, we've had sellers that'll say, well, I've never lived in the house, it's been an investment property, I'm not filling out the property disclosure form. That is not exempt, just because you haven't lived in the property does not mean you're exempt from filling out the property disclosure form. Again, we can't tell them how to fill it out, so if you give it to them and they cross out everything on it and sign it on the last page. That's what they did. Right, so just so you're aware, you never answer on the disclosure of how to fill it out. And then if there's anything the seller's providing as far as a disclosure, something that you don't want them to disclose, are they getting a divorce, are they getting married, whatever the case is, then they might specify that, but defects, you cannot say, oh, we won't disclose those. But confidentiality with the seller, you can say, because there's a lot of times where somebody will say, I don't want people to know we're going through a divorce, simply because they'll think they can get a better deal on the house. So you would state that, the seller wants that to keep quiet. But I will also tell you, when somebody's getting a divorce, it doesn't matter. Usually what happens is you go in the house, there's one set of clothes, the other side of the closet is vacant, you kind of know what's happening, so you can figure it out, things like that. And then again, it just says confidentiality. I think the biggest thing to understand is, on the confidentiality side, is as a listing agent, you have to keep your seller's information confidential. But when you get an offer on the property and that seller says to you, yes, this is a great $250,000 offer, but if you can find another buyer that'll pay $260,000, I'll accept that. You can, according to your seller's written, put that in writing, you can go shop that offer then. You could say, my seller said, I have an offer for 250, if anybody will give me 251,000, then we'll take that offer or we'll review that offer. You can do that. When an agent gives an offer to a listing agent, there is no duty of confidentiality of that, what that offer is. So when you're in a multiple offer situation, you need to ask the seller first, can I disclose that you're in multiple offers? That's first and foremost, because some sellers might say, no, I don't want you to disclose I'm in multiple offers. So that could be something that's confidential too. Ask the seller at the time of the listing, can I disclose multiple offers or not? A lot of times an agent or a buyer might get weirded out by multiple offers and say, never mind, we're pulling our offer, we don't want to be in multiple offers. Well, now you've just killed that for your seller, even though they asked you not to disclose that you were multiple offers, so you've harmed your seller. So that's what I mean by confidentiality. Anything that they say that's confidential, you need to make sure that you keep it that way. And then, are there any excluded fixtures? When you ask the seller that, really have the conversation. Fixtures are anything that are attached to the property. That means TV wall mounts, those should stay with the property. Curtain rods stay with the property. If there is a shower rod that is bolted to the wall, that stays with the property. You'd be surprised at the amount of bathroom mirrors that are not bolted to the wall anymore. They're just a mirror hanging on the wall, and The seller says, I'm taking that bathroom mirror with me because it's personal property, it's hung on a nail, it's not screwed to the wall. The buyer gets there and goes, where's the bathroom mirror? It was not affixed to the property. So have those conversations with the seller. What is affixed to the property? If grandma's light chandelier is in the foyer, it's probably best if you take that down before we show the house or take pictures of it. If you don't want to, fine, we have to exclude it here, but you as the agent, as the listing agent, get yourself into trouble. I know I have, because I excluded it on here. I said something in the broker remarks in the MLS that it was excluded, but we didn't exclude it on the purchase agreement. Well, guess what? It's going with the property now and they're a little upset with me. I've had to buy a refrigerator before. So that wasn't a fixture, but I've had to,
You can't buy.
once you're in this business for a while, you will have contributed to home warranties,
Yes,
radon systems, all kinds of things.
done it all.
What, cause like, that was something I was struggling with in my test, was like, there were certain ones that it was saying that. It could be like either or, so it's confusing, like microwaves and stuff like that, is that considered a fixture?
If
Or
it's
does it
built
depend
in. If it's a microwave that's built in the cabinets, yes, but if it's a microwave sitting on the countertop, that's
But
personal
what if
property.
they installed it, like, it still doesn't matter, it doesn't matter.
It doesn't matter.
Okay,
It's affixed to the property, it
Okay.
belongs to the property. Same thing with plants. You might have a rose bush that it was your great great grandmother's and you've, each year you've helped nursed it back to health and it's this beautiful thing. If you're taking that out of the ground when you're leaving, you better exclude it because it's part of the real estate.
Okay.
Yeah. Now, if it's in a pot,
yeah,
that is not considered part of the real estate.
I think Chrissy.
So it's if it's a fix, so that's how you have to think of it. Cause we've even had people say, well, the Ring doorbell is not affixed to the property, it's on there with double-sided tape. But like mine is screwed to the wall. So you really have to.
Yeah.
Make sure the seller understands what it is that's affixed to the property versus what they can take with them.
but like keys, aren't those considered real or they're
Keys,
not personal property, right,
mailbox,
because it goes with the,
it goes with the real estate.
okay,
Yep, keys, mailbox, all those types of things, mailbox keys, garage door openers. Yeah, they're not affixed to the property, but they belong to the property. But like curtains that match your flower print bed cover, the curtain rod is affixed to the property, but the curtains are personal property. It's affixed to the property, doesn't mean it goes with the property, but the garage door opener is affixed to the property and it has remotes.
Okay.
Locks are
Because those are
affixed.
part of
That's right.
that whole
It's
mechanism.
part of that, yep. And you'll get into this to say, like I said, I've got a client right now that has a Vivint camera. This camera was amazing. And it's got lights and all these things on the back of the house, whatever. She's leaving it because it's affixed to the property and she doesn't have any use for it at her next home. But she could exclude that because she paid for that security system and might say, those are going with me to my next house.
Yeah.
So that's why you have to ask these questions to your seller, because a lot of times they'll go, oh no. But the Nest thermostat that they paid $300 for is affixed to the wall and with wires, but they want to take it with them.
Yeah.
So that's a problem. Unless you exclude it. Alright, and then home warranty is either yes, you do have it, no, you don't have, you're not offering one with the listing, it can always be negotiated later. If there are any point of sale inspections, one of the things that I love to point out in this, and none of our agents do it, but I'm just gonna say that it does say that any municipal point of sale inspections or whatever, the seller shall apply for them at the seller's expense timely to obtain such inspections, which means when you get a listing agreement, technically in the state, in Stark County, you have to have the septic inspection started. So if the seller's not willing to do that, you better cross it out, because now the buyer's gonna pay for it.
Yeah.
Right, so just be aware that if there's a point of sale inspection, with the way we have it written, is the seller is responsible to pay for it and have it done. So, and then the seller obligations just says the seller needs to maintain the property, it's not our job to maintain the property at all. We might drive by it and say, oh yeah, everything looks good from the outside or whatever, but they need to winterize it if they're not gonna be there, they should shut water off, shut gas off, whatever it is. We aren't responsible if the roof starts leaking or the basement floods or anything like that. We are here for the real estate services only. That is up to the seller. We can be kind and say we'll stop by to make sure everything's okay, but if there's damage in between the time, it's not our fault. Same thing, we just had an agent, a home got broken into and we had to take it off the market. Like they threw paint all over the walls and did all kinds of things. All right, and then cybersecurity again just says that we're not gonna ask you for any of your personal information, things like that, and that this is a binding agreement for real estate services only. Again, you need to sign it. And if you're on a team, and so if I'm on a team and Ashley is my team leader or the rainmaker, Ashley should be signing it and I'm signing it. Because we're doing this together. It's
Mhm.
not just one agent or the other. And this is because the seller then understands who represents them in the transaction. So, any questions about that agreement? That's enough, right?
That's enough.
All right. Well, it's 12:28. Thanks, guys, for being with us today. I will let you get back to your day. If you do have questions, you know, you can always get a hold of me. So, thank you.
Thanks, Rich.
Doug said thank you.
You're welcome.